All right, good afternoon, everyone. We're back on the docket from first appearances, our afternoon hearings, December 7th. Mr. Romero, you're there at the main jail.
I sure am, Judge. Good afternoon.
Nice to see you again. I do have a private attorney here for a reset from yesterday. Yes, Mr. Eduardo Alvia Fuentes.
He's here, approaching, Judge.
Very good. We have attorney Richard, is it Cooper?
Afternoon, Judge.
If you need paperwork, I'm happy to share with you.
Yes,
Mr.
Judge.
Mr. Cooper, good afternoon. Your attorney's here. I have, just give Mr. Cooper an opportunity to get settled. Counsel, it's Richard Cooper for the record.
Yes, Your Honor.
Thank you. So, Mr. Avila Fuentes, we were here yesterday. You asked to reset this matter to today. I gave you an opportunity to have your hearing within the 24 hours. You indicated you would prefer to move this matter to this afternoon so that your attorney could be present. We're here to make a decision regarding probable cause as well as any bond amounts. You are currently being charged with four different charges. The first is an aggravated assault with a deadly weapon without intent to kill. Second is a touching or striking battery. Third is a resisting officer without violence. And four is making a threat of harm to a public servant or family. The three last charges that I indicated carry with them a standard bond, which I'm always happy to readdress. The first charge, however, is left at a zero bond for me to determine here today. I have had an opportunity to review the probable cause affidavit. Mr. Cooper, any argument as to probable cause?
Judge, I'm still reviewing the probable cause affidavit.
Okay.
At the moment, I frankly don't see any argument for probable cause. However, I would ask Your Honor to grant the defendant a bond in the matter so that he may. Sorry, give me 1 second. Judge, I know that the defendant is a homeowner. He has a family here, family with whom I've dealt with. I've met them, and I know that he has a stable job. And while I can, in good faith, make an argument against probable cause in this matter, I would ask that Your Honor set a bond.
Okay. And the residence that this is alleged to have occurred in, it appears that there are other folks. Is this his only residence, or does he have somewhere else to live?
Judge, this is his only residence as far as I know, but I know that his parents do live locally, and perhaps he could live with them in the meantime during the course of this case. Excuse me. I do know that he, just because I've represented him before, I do know that he does own this home, and that this is a source of income, is renting rooms.
Okay, understood. All right. Mr. Linder, anything on behalf of this gentleman's background and a recommendation for the bond amount on count one?
Yes, Your Honor. I would note he was arrested January this year for resisting without violence and pled that out in June. What's noteworthy, I was reviewing the probable cause affidavit in that case. It involved the same residence. Police were called to the scene because there was a disturbance involving his roommates again. He was acting aggressively towards his roommates. The allegations are he threatened a police officer while they were investigating the matter as well. Noting DUI 2002, resisting without violence 99, DUI and battery 1999, possession of cocaine in 1996. Your Honor, based on his criminal history, the allegations in this case, the strength of the evidence, the state would be requesting a $15,000 bond on count one. I'm fine with the standard bonds on the other counts. No victim contact, but based on the allegations, I would also be asking that he be supervised by pretrial release with the GPS monitor should he post these bonds.
Does your client have the ability to post that significant of a bond?
Judge, from my dealings with Mr. Avila Fuentes and having represented him in the past, I do know that he's not the wealthiest man in the world, and I do know that he's had some recent financial troubles, and I would ask that Your Honor take that into consideration in considering that multiple $15,000 bonds is tantamount to no bond at this point. I'm going to have to get in contact with his family to see if they can talk to a bail bondsman, if Your Honor is not so inclined to reduce the bond. But at this time, you know, I understand that the allegations, even as they are very serious. And
Well, he owns this home, you're saying, so we would have, technically, could have collateral based on the owning of this home. If someone can, Mr. Romero, can I bother you to unmute the microphone so we can talk to the defendant regarding?
Here you go.
All right, Mr. Avila Fuentes, you have your attorney here. I just need to make a determination regarding a bond amount and what monetary bond you could actually afford. And you can talk to your lawyer about what to do if you have roommates that you wish to evict, or if it's your home and you don't want them there anymore, whatever the case may be. But for the time being, until this case has been resolved, I'm gonna have that you have no contact with anyone that you were involved with here at the residence. And I understand this is your home, but you have a lawyer, so you have legal avenues open to you to get possession of your home back. But for the time being, you can't go back home while they're there. Do you understand that?
Okay, yes, I'll discuss it with my attorney and we'll go from there.
Okay, but until anything is done legally, you cannot go back there. You understand that?
Okay, ma'am.
Okay.
One more question, ma'am.
Wait,
Yeah,
I'm
one
not
more
finished yet. I'm not finished yet. You're not to have any contact, either directly or indirectly, with any of these folks at the residence. Specifically, a David Mullen and a Leslie Rodriguez Romaine. You understand that, sir?
Yes, ma'am.
Okay. Now, if your lawyer needs to contact them for reasons relating to the possession of the residence, that's a different story. But you can't call them, you can't text them, you can't email them, you can't have any of your family members or friends contact them in any way. You understand?
I understand, ma'am.
And then if you need to retrieve any of your personal items, your lawyer will make a necessary arrangements to have a police escort so that you can have your your shaving and your toiletries and things like that removed for the time being. You understand?
Yes, ma'am.
Okay, also the state is recommending that I consider a GPS monitor to make sure that you don't go back to the home and cause any more issues or any more problems. So the only thing, and I think that that's a good idea, my only other concern now is what bond I'm going to set for count one. He's suggesting $15,000. Considering that I'm inclined to put you on a GPS, I may be willing to reduce that somewhat. I just need to find out from you what you think you and your family might be able to afford.
Ma'am, the savings that I got right now, they're pretty much about $5,000, about it.
Okay. So you would have some cash to put towards a premium for a bond, for a bondsman.
Yes, ma'am.
Okay.
I can put my house as collateral and just pay the minimum.
All right, yes, Mr.
Your Honor,
Leonard?
just a couple things. One, just to make the record clear, Your Honor, Leslie Rodriguez Roman was the arresting officer in the case. He's not one of the,
But she's also a
No,
victim.
no, I know, I'm just,
Okay.
because
Oh, okay. All
I
right,
just want to make it
understood.
clear.
Okay, that's,
And the only, and I meant to ask earlier, the only other condition I would ask, Your Honor, is that court order that he not be in possession of any firearms or weapons. And so forth.
obviously, yes, I would make that a condition of his release.
we have no objection to that as a condition of his release.
Yes.
Your Honor, the only thing that I would ask, if Your Honor was inclined to put him on pretrial, perhaps it could be pretrial level 1, I believe, which is not include the GPS, because the, I'm sorry, so level 3, I believe, level 2,
allowed to go to school or church.
but it's still a GPS monitor.
Anything with a level is going to have a GPS monitor.
Okay,
Yes.
thank you. So if we could reduce the cost of that as much as possible, if Your
Well,
Honor
it's a
could.
$5 a day charge, and I don't see a problem with having to pay the state back for the cost of having a GPS. What I'm willing to do is consider a lower monetary bond. My bigger concern is just him just staying away from these folks. So I would be willing to, I'm just trying to calculate what's there already. I'd be willing to go as low as $5,000 on count one.
That one is the aggravated assault, Judge?
Yes, sir. So it would be 5,000 on count one, 1,000 on count two, 100 on count three, 3,500 on count four, for a total amount of Eight, $9,100. And I am going to require GPS monitoring. He's permitted to go to work, school,
same paperwork
his
I
place
have.
of worship, those types of things. So that would be level 2. If he's permitted to go to work, that's level 2?
That's correct, Your Honor.
So level 2.
Okay.
Your Honor, does the defendant know where he would be staying until?
What's the address of your family members that you're going to be staying until you can get back to your residence?
121 Miami Gardens Road.
121 Miami Gardens Road?
Yeah, 121 Miami Gardens Road.
And that's in Miami Gardens?
That's correct.
Okay.
That'll be Hollywood, Florida 33323, I do believe.
Oh, it's actually a Hollywood address?
Yeah.
It's on Miami Gardens Road in Hollywood?
In Hollywood, yeah. It's 121 Miami Gardens Road,
Hollywood.
Hollywood, Florida 33023, I believe.
Okay, we'll double check the,
Would the defendant be able to provide a name and number for someone?
who's the family member that resides there?
My father, my mother.
Their names?
Juana Avila y Eduardo Avila.
Okay. And a phone number that we might be able to reach them at so we can verify the
Is
address?
954 963 6047, I believe. I'm not sure, ma'am.
We'll double check it. We'll double check it with you. If we can't reach them, they'll interview you at the jail if
Okay.
necessary, okay? All right.
Yeah.
All right, and then, counsel, you can talk to your client about, the possession of the residence.
I will, Judge.
All right?
Thank you, Your Honor.
All right,
Thank you very much.
both.
Appreciate hearing me out, turn.
Yes, sir, what?
Your Honor, when can I talk to my attorney?
He's gonna come see you, okay?
Okay.
Thank
Okay,
you.
ma'am. Thank you. Thank you.
All right, going back
Thank
to
you,
the
Judge.
regular docket, then, let's see, Eileen, Eatman,
North Broward.
thank you. Good afternoon, ma'am.
Good afternoon.
We have, that's very, very loud. We have a,
Judge, her bond was posted.
oh, your bond's been posted, ma'am.
Colleen
Yes, ma'am. Your
Yes.
bond, someone posted your bond for you.
Someone posted my bond for me?
According to our documentation. You sure about that? She looks very quizzical about it. Somebody posted your bond for you. You have a guardian angel out there somewhere. I'm finding probable cause. You had a $2,500 bond. Someone posted it for you, so you'll be processed for release, okay?
Okay, thank you.
All right,
Good
bye-bye.
luck, Colleen.
Thank you.
All right, next we have Daphne
Ms. Sannon bonded, Your
Sannon.
Honor.
She bonded? Okay, finding probable cause.
Sannon.
Next we have Miss Venero.
She was very popular this morning, Your Honor.
I believe she informed she has private accounts.
She does have private count. This is the one with Judge Siegel where they were trying to get the Nebia order lifted.
It is? Okay.
Your Honor, I can tell you, she has been set for a Nebia status in front of Judge Siegel tomorrow morning.
Tomorrow morning. Okay. All right, very good, ma'am. So we're gonna leave everything as is. I'm finding probable cause at this time. You're seeing your judge tomorrow morning to make a determination as whether you would be permitted to bond out, okay?
Judge,
Yes.
even though count 2 is a NC per the Nebia order, that charge is already RR, so we just replace that.
So, number 2, the drug paraphernalia?
Yes, it's
Okay.
RR on the Nebia hearing.
Okay. All right, very good. All right, ma'am, you'll see him tomorrow. Good luck to you. Next, we have Richard Forrest.
He's here, President Judge Maine.
Okay. And then we're gonna go, after this gentleman, we'll go out of turn and take Mr. McLawrence's client. We have Richard Forrest. Mr. Forrest, good afternoon. I have four charges pending as it relates to you. I have 3 counts of resisting an officer without violence. Only one of those counts has a bond amount of $100, and then there's a loitering and prowling, also doesn't have a charge on it. Can you post a $100 bond, sir?
He informed me he doesn't have the financial ability plus the monetary
She's
bond.
set for tomorrow. And encroachment.
And I think there are too many resisting without violence counts here anyway, Judge.
Well, none of them have any bond attached.
No, I understand that, but certainly I think that's something you can take into consideration as well.
Well, the thing I'm taking into consideration is the alleged allegation that the officers were dispatched to an attempted burglary is what I'm taking into consideration. Irrespective of the charge that he's actually been, arrested on. What's his background, please?
Your Honor, I'm getting hits out of Louisiana, Missouri, New York, Indiana, and Kansas. He had a resisting without violence, trespass, and unlawful use of false name ID from June of this year. He pled those charges out to time served in July. They were out-of-state holds at that time.
Anything else you want to let me know?
Nothing from the state judge.
No? Anything else from you, Mr. Romero?
Not at this time, Judge.
All right, I'm gonna increase his bond on count 1 to $1,000. The rest will remain no charge. I'm finding probable cause. Good luck to you, sir. Mr. McLawrence, we're gonna go ahead and take Mr. Patrick Wells out of order. I'm gonna enter an order appointing you as his counsel.
Thank you, Judge. Mr. Wells is in the main jail.
Thank
Patrick
you.
Wells?
Mr. Wells?
He's in North Broward, Judge. I just spoke with him.
Oh, sorry.
Okay, thank you. Sorry about that.
No problem. Mr. Wells at North Broward. Anyone there? Mr. Wells, hello, good afternoon. I have appointed Mr. McLawrence here for you on behalf of is it the trespass or both counts that you're representing him on, Mr. McLawrence?
Only count 2, the municipal ordinance trespass at Imperial Point Hospital, Judge.
I represent him on count 1, Judge. Mr. Wells indicated to me he might consider resolving this case.
And have you had an opportunity to speak to Mr. Wells, Mr. McLawrence?
No, Judge, I have
Not
not.
yet.
Not yet.
Based on my review of the probable cause affidavit, I'm not inclined to resolve this matter here today. I am finding probable cause. He appears to be scheduled for a hearing with his assigned judge on the 13th next week at 9 a.m. You can talk to that judge about whether you want to resolve this matter with that judge or not. Good luck to you, sir. Next, we have Ronald Davis.
So I just wanted to let you know, I'll make your turn.
Mr. Davis, where's Mr. Davis?
Here, main judge?
Thank you. Hello, Mr. Davis. I have a capias for you revolving around a trespass on private property. Public Defender's Office represent him on that?
The municipal ordinance case, Judge.
Hollywood?
That would be the office of Steve Shate.
Okay. Mr. Davis, are you interested in me reviewing your paperwork in order for you to resolve this matter without the assistance of an attorney, or would you prefer to have a lawyer help you?
Yeah, the first option.
First option, okay, because right now your bond is $100, so I don't want to force you to make a resolution in this matter if you'd rather have a lawyer. I need to find out from you, are you waiving your right to an attorney right now?
No, I won't waive it.
You want to waive it or you don't?
I don't.
You
I
don't?
want to, excuse me. I wanted to go on my record. I think of a trespass.
I'm sorry, I'm not following you. Say it again.
Oh, no resolution.
You do not want to resolve it? Do you want to take care of it today and possibly try to get out, or do you want to wait and have
Yeah, I want to take care of it.
Okay, all right. I'm sorry if I wasn't making myself clear. All right, so I'm going to read the facts of the case and see if I want to try and take care of it for you today, okay?
Just gonna ask me.
All right. You understand you have a right to have an attorney right now, and you're going to, at this point, you're going to be representing yourself. You understand?
Yes, ma'am.
Okay. Please do not talk about the facts of the case. I just need to make a decision as to whether I want to try and get you released or not, okay? Okay.
Yes, ma'am.
And in the meantime, Mr. Linder, you want to tell me about his background?
Judge, he's not on my list, so I really can't check anything other than local, but the only thing I saw locally, 2015, excuse me, a municipal ordinance lodging on city-owned property.
Okay. And this case number is 300?
I think it's 3,000.
3,000, yes, 3,000, okay. All right, so sir, they're claiming that you were at an address of 2526 Sheridan Street and that you've been asked not to be there, and I'm gonna just make you promise to me that you won't go back to this location again. Do I have that promise?
As well.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth?
Yes, well.
All right, you can put your hand down. You have a right to have a trial in this matter. You're telling me that you want to give up your right to a trial today. Is that correct?
As well.
All right. Is anyone forcing you or threatening you in any way to plead no contest here today?
Yeah, no contest. I was.
No one's forcing. I'm not forcing you, am I?
Yeah, no contest.
Okay, very good. I'm going to go ahead and accept your no contest plea. I'm going to withhold adjudication, take judicial notice of the time served, and give you a year to pay any court costs. So, sir, they'll process you to be released. Good luck to you, sir.
Thank you, ma'am.
All right, take care. All right, next we have Mr. Luma.
Mr. Kevin Luma, he's here present, Judge.
Thank you. Good afternoon, sir. I have 3 charges pending with regards to you. One is a possession of cannabis. Another is contributing to the delinquency of a minor. And the third is a loitering and prowling. You have one of those charges carries with it a $500 bond.
I have a probable cause argument on that count.
Okay, go right ahead.
Judge, the probable cause affidavit indicates that Mr. Luma and 5 juvenile defendants with criminal histories, including burglary, were observed walking in the area. I don't see anything in the body of this probable cause affidavit that indicates Mr. Luma did anything to contribute to anyone's delinquency or dependency. It doesn't even mention him really even having any contact with them. It looks like one of the juveniles threw a glove down, another one, or the same one, destroyed his Social Security card. That has nothing to do with Mr. Luma. He loitered and prowled. I think it's even questionable as to whether this is loitering and prowling. It looks like they were walking. It doesn't look like Mr. Luma did anything that would cause this officer to be concerned about the safety of anyone in the area, other than being in the presence of some juvenile delinquents. There's nothing about him loitering or prowling. It says they were walking. So I don't think there's probable cause to support count 1 or count 2.
Well, count 1 is the possession of cannabis.
Oh, I mean, count 2 or count 3, I'm sorry.
Okay, no problem. Mr. Linder?
Your Honor, I would agree as far as count 2. I think based on the totality of the circumstances, I think there's probable cause for loitering or prowling based on all the allegations.
So that would mean he would be released outright on count 2, which is the bondable offense?
Well, they're all, Your Honor, they're all bondable. It just,
Okay.
you know.
And are you requesting that I impose a bond on the possession of cannabis, or just release some ROR on the other 2 on the other 2?
One moment, Carrie Ann, you don't have any notes on him, do you?
Do you have any information regarding this gentleman's background? No. He's not a charge that has a background on.
Yeah, I wouldn't necessarily have an issue with him not having to post a bond. My only concern, based on the nature of the allegations, I don't know what his ties to the community are. I'm showing he's only resided in Lauderhill 3 months. I know he doesn't have any local charges. I don't know if there's been anything outside of
I
that.
can give you some additional information,
The court
Judge.
would like, I can run.
Well, if this is the, let me double check his date of birth, because I have some other matters here. Sir, do you have a middle initial?
Yes, ma'am.
What's
TK.
Okay. I have some other matters that I can see that you all may not be able to see.
Yeah. Something's not right there.
Different date of birth?
Well, no, this up.
I'm considering a $100 bond on the possession of cannabis charges. Your client have the ability to post that?
From what he told me, he doesn't believe so. He's self-employed. He works on tiles and grout installing. He works with his father. They live in Lauderhill. They share an apartment, Judge. So he doesn't think he could go ahead. His father's going to be able to afford to post that $100 bond. That's why he's requesting, Your Honor, if you would consider releasing him ROR, Judge.
Okay, and this is Lauderdale, we have an address for him in Lauderdale Lakes. Is this a correct address for you, sir?
Say your address.
What's
No,
your-
ma'am, it's 2920 Northwest.
Wait,
56
slow down.
Okay.
29,
20 Northwest 56th Avenue, Lauderhill, Florida, apartment B304.
Okay, great, thank you.
B304.
Yeah, B as in boy.
Okay, and which one?
Lauderhill.
Lauderhill?
That's the address on the booking sheet.
Zip code 33313.
Except for it's missing the B part of the address.
Your Honor?
If you look at the address, it says apartment 304. It's supposed to be B as in boy 304, so his address is wrong right there. We need to make sure that gets
Well, no,
fixed.
one thing I'm gonna-
Yes, sir.
Well, Your Honor, and I don't know if this is indicated in what you have, because I just ran a check real quick.
I have some old juvies.
Yeah, and I guess this was what my concern is, and first, this is not his correct date of birth that's listed here.
Sir, what's your date of birth, please?
9/15/98.
I have 9/15/96. Carrie Ann, do you have the same thing? I'm looking right here with every. That's what's in.
All right, so sir, we're gonna put this B on in your address. Hopefully, it'll get taken care of. I'm gonna warn you right now that they found no problem. I'm finding no probable cause on count number 2. However, I am finding probable cause on counts 1 and 3. The state attorney's office is going to be pursuing those charges. So you'll be getting a new hearing date in the mail regarding those charges. If you miss court on those charges, they're going to end up issuing a capias for your arrest, and then you're going to end up sitting in jail. Apparently, there's some sort of issue regarding what date of birth you have, so you may want to bring some sort of proof as to when you were born for your next hearing, so that your lawyers can fix any mistakes that there may be. It appears from my review of the local Broward circumstances, he hasn't had any arrests since, looks like any issues since 2014. Do you have something else?
He was out of Georgia. It was dropped though, March of this year.
Okay. All right, sir, I'm gonna release you on your own recognizance on counts 1 and 3. And the chips will fall where they may. Good luck to you, sir.
I'm sure it's,
All right, next we have Santos Walcott.
looks old. Maybe he just looks old.
Yeah, he's in North Broward, Judge.
Okay. All right, Mr. Walcott, waiting for you to come to the podium, North Broward. Thank you, Mr. Walcott. Good afternoon. I have 2 matters here before me. It appears that you have capiases for misdemeanor matters, both of them having a $500 bond on each of them. I'm assuming that did he miss hearings?
Yeah, when he was originally arrested on the resisting without violence in March, he was also arrested for an active capias on count 2 then. So it looks like this would be at least the second time he failed to appear in court on count 2.
And sir, you have a status hearing on Monday at 11 o'clock with your assigned judge. I'm gonna leave these 2 bond amounts in place.
I didn't know.
And you can let the judge know on Monday that you didn't know about it, and if your reasons for missing court are reasonable, then they'll go ahead and reduce your bond and/or maybe plea your case out, I don't know, but you'll see the judge on Monday, okay? Next, we have,
Judge, when you have a chance, I know I'm being, if we could call a gentleman out of turn.
absolutely, which one would you like?
Roderick Edwards, I believe he's the gentleman that, I believe someone over there was gonna try and contact his attorney, Mr. Polay.
Yep,
I left a message for Mr. Molay. I did not hear back from him.
Mr. Edwards, hi, Mr. Edwards, I actually spoke to your attorney. He informed me that he does not have the ability to take your case right now. He's up in Palm Beach today in court in Palm Beach. Tomorrow he's out of the office. He indicates that he does not have the ability to take your case right now, and he suggests that you go forward with the public defender's office for the time being for your hearing or represent yourself, but he's not going to be able to take your case for purposes of your bond hearing. So I need to find out from you how you want to handle this. But he's not coming. He's not coming, and your family's not going to be able to hire him right now. So what do you want me to do?
I'm just saying, having a public defender represent me, I can't be able to give you the facts of what really happened, what really going on. I don't really put to be locked up now.
Okay, well, again, you're welcome to represent yourself if you like, or you can hire a different lawyer other than the gentleman that you asked me to call. But I specifically spoke to him on the phone myself, and he absolutely told me that he cannot represent you at this time. So if you want to have your family call another lawyer, I'm happy to let you do that, but I just need to know what you want me to do regarding your bond hearing today. Because your bond hearing today, you have 6 charges pending. One of them I have to make a determination as to what your bond amount should be in order for you to potentially bond out. From what the other attorney told me, that the public defender's office is representing you on some other cases, so.
Yeah, but them cases ain't never got filed yet, though. I got released on for doing 33 days, and the state said they ain't have no information to even file that charge on that. I've been waiting for a court date. It ain't been no court date.
Okay, well, again, you want to represent yourself today on this resisting officer with violence, or do you want to talk to Mr. Romero about me posting a bond for you?
Yes, I suppose Rivera got to say.
Okay, all right, very good. So, have a seat. We'll get to you as soon as we can, okay?
Thank you.
All right, next we have Ramon Gonzalez.
Judge, he was a medical reset. He's now a medical loan.
Okay, I did make a probable cause finding yesterday. So we'll just keep trying to reach him until we see him. Next we have Dylan Senor.
He's here, President Judge Jermaine.
How you doing, Judge?
I'm very good, thank you for asking. I have quite a few charges pending here for you. Unfortunately, 2 of them, is it one of them or 2 of them? Yeah, one of them has a no bond hold on them. Actually, I don't know why the other one doesn't. I have a total of 7 charges here for you. Let's go through them real quick. It's a resisting officer without violence, driving while license suspended, first offense. I have a couple of traffic matters, vehicle without headlights, improper turn, unlawful speed. And then I have 2 violations of probation for you. One of them is on a 2014 case number, and the other one's on a 2016 case number. On the 2016 case number, it appears that the warrant is requesting that you be held no bond until such time as you see your judge. And other than that no bond hold, the only other thing you have is the $100 on the resisting without violence. Your hearing date is scheduled on Monday at 11 o'clock in the morning.
On count 6,
That should be no bond as well?
no, ma'am. His probation was terminated.
terminated on 6? Okay, that's why it says 0. Okay, so you don't have to worry on count 6. Your probation was terminated on the 2014 case number.
That mean they got rid of it?
Correct, it's been terminated, so you're no longer on probation for the 2014 case. However, you're still on probation on
It's saying
2016
here
case,
0.
according to the document.
All right.
Well, it would say 0 because it's a no bond.
No, it says, it doesn't say no bond, it says NA. See? I know, that's what I thought that was odd.
Yeah, that was definitely wrong. So on count 6, can we reflect probation?
Sure, okay, so sir, we're gonna reflect on count 6 that your probation was terminated on the 2014 case number, so you don't have to worry about that one. So you'll see your judge on Monday on just the 2016 violation, all right?
The 2000 and, all right.
2016, you had a 2016 case number that's a violation of probation.
If, like, when I go to court on Monday and my judge comes up with a solution, do I have to bond out on the $100?
Yes, you would. Do you not have the ability to do that?
Let's say when I go on Monday, my judge can, like, you see how you have the power to, like, reduce, and he has the power to do that too?
No, they won't, because it'll be a misdemeanor case and you're going to a felony judge. Mr. Romero, is he asking that I reconsider the $100 bond?
I think that's what he's asking, Judge.
You don't have $100 to post, and if your judge resolves it?
No, not at the moment.
Okay, hold on, let me take a look at the allegations, and I'll tell you whether I'm willing to reduce it, okay?
All right, thank you so much.
You're welcome. So,
Judge, actually, after speaking with Mr. Senior, he wishes to have the bond remain intact, the $100.
I was gonna say, he probably would wanna do that, so let's do that. All right. I'll leave everything as is. You'll see your judge on Monday, okay? All right, next is Mr. Brown. Where is Mr. Brown? Which jail? Where- Mr. Brown, is that you sitting there? Yes.
Byron Brown is here present, Judge of Maine.
Thank you, Mr. Brown. Unfortunately, I'm not gonna be able to help you much. You do have a violation of probation. Your judge has scheduled a hearing for you next week on the 15th at 8:45. You'll be held no bond until you see your judge, okay?
Yes, ma'am.
All right, take care. Cody Hudson?
He's here present, Judge of Maine.
Mr. Hudson, unfortunately, it appears that you have 3 separate cases that you violated your conditions of community control on. You're being held no bond on all 3 of them. You do, however, have a hearing as early as Monday at 8:30 in the morning. You can talk to your judge on that day regarding your violation, okay?
Thank you.
All right, good luck to you, sir. Next, we have Randy,
Mackinson, he's here
yes.
present, Judge of Maine.
Thank you.
Judge,
Sir,
he believes his may have been terminated. Is there any way Mr. Lunder could look in Odyssey to see if it reflects that?
we think it was terminated. Let's
This
look.
guy's case. Please see the paperwork. Look for the part of the beer. It's a felony.
Well, this warrant, it looks like it was signed back in 2014. So it would have had to have terminated before that 2014 date, yes?
No, not necessarily, Judge. Depending, I believe, on the nature of the violation, if his probation was told or not.
Well, I'll tell you, it's using intoxicants to excess, positive drug screen, failure to report, failure to pay costs, absconding, changing residence, failing to make himself available for supervision, absconding.
And I don't know that the law that Mr. Romero is referring to was in effect at the time of the violation.
Right. So, your hearing's next week, sir. You can talk to your judge at that time. It appears that from the face of the paperwork that I have here, that you have violated your probation and that you violated it prior to the expiration of your,
What's it say?
because I'm looking, let me see, I'll tell you the paperwork, what the paperwork says.
He's due to expire in 2015.
I have a supervised population information absconder, and a scheduled termination was to be April 23rd, 2016. So, again, the judge that's assigned to the case will have all the files there, and you all can figure it out then, but it appears that he was on active probation when he violated. Okay? Good luck to you. Mr. Scott Herndon.
Mr. Herndon, come on up.
Good afternoon, Judge.
Good afternoon, sir. I have unfortunately a no bond hold for you. There's a violation of probation hearing scheduled on Monday morning at 9 o'clock. And you're to be held no bond until you see that Judge Elijah Williams? Is this right?
That would have maybe been the judge that signed it back in 2002.
That is, wow.
That division is probably, with the new judge, Division FP, I'm not familiar
Okay.
with the judge in that division.
All right, I remember, that was a long time ago. Okay,
It was
so,
also my understanding that this had been resolved, this whole case was resolved in 2009 in April. I was sentenced to time served.
Oh, so it may be terminated, is what you're saying?
I believe it was. I believe I was sentenced to time served in April 2009.
Okay. I'll look it up right now, hold on a second.
what do you guys see?
One moment.
Okay. And someone at one of the satellite jails, your mics are on. I'm not sure which one, but if you could turn off that mic, I'd appreciate it.
There was a VOP hearing in 2009. It doesn't show what the basis, what happened as a result of that VOP.
We're gonna have to order the file then. Maybe it just didn't get updated and it's on the paperwork. Sir, you think you resolved it back in 2009?
Yes, ma'am. I flew down. I had applied for disability. I was approved, but the warrant was outstanding here in Broward County. I flew down from Indiana. The judge allowed me to surrender in open court. I believe it was Judge Johnson, I want to say. I could be wrong about that.
Yeah, you could be wrong. You're wrong about that. We don't have a Judge Johnson.
But I surrendered in open court. He sentenced me to time served in open court. I served 24-hour administrative probation that day. I was paid $50, and I flew back home to Indiana on Monday morning.
Do you reside here, or did they bring you here?
I was brought here for this, ma'am.
From where?
Just recently from Sarasota.
All right. And were you in custody in Sarasota?
Just since Saturday afternoon because of this warrant.
Because of this warrant? They picked
Yes, ma'am.
you up in and you live in Sarasota now?
I actually live in St. Pete. I just happen to be visiting a friend in Sarasota on Saturday. So I've been in custody since Saturday based on this warrant.
We have to get his file out of archives, right? We have to request the file. Can I request the file? Do you think we can get it back? We can get it here by tomorrow?
That's the thing.
He
What he's saying in 2009 is he surrendered in court, so it's not.
I don't want to make you wait a whole weekend to deal with this if you
No,
did.
'cause he wasn't taken into
It does
custody.
show that you resolved in 2009.
No.
I don't know how I can expedite it though. It usually takes a few days to get it out. Can we call? I'll make it a double, triple emergency. So can we get? Well, I'd like to get it here in the morning. Can we make a phone call and get it here as soon as possible?
Do me a favor, tell whoever's here tomorrow morning what's going on with that.
Sir, I'm gonna try and get the file tonight, so that we can put you on the docket for tomorrow. If I can confirm that, I'll get you released tomorrow, okay?
Thank you so much.
All right.
Thank you.
So we're resetting him for tomorrow morning. I want the file. I want somebody to go get it. If I have to sign an order to that effect, I will.
You think we should do it for maybe in the afternoon?
Well,
so
if I wait
give
till
him
the
a little
after,
bit more time?
I know, but if I wait till the afternoon, by the time they process him, he'll spend an entire 24 hours still left in the jail.
Yeah,
He
you're
won't
right,
get
Judge.
out
You're
until
right.
late tomorrow night.
And if you do it in the morning, and for some reason it's not here, then at least you can
Yes,
always.
and if I do it in the morning and it's still not here, at least I can roll him to the afternoon and find out who.
Yes, Judge.
Okay. So I want him here in the morning,
Very,
please.
very wise decision.
Okay. Well, thank you. It's very, very rare someone says I made a wise decision. Just a little levity there, folks. Anthony. Anthony Andrews, please. Where's Mr. Andrews? Good afternoon, sir.
Good afternoon.
Doesn't look like I can help you much here. You do have a no bond hold on a 2012 violation, as well as 2 capiases for misdemeanors, both of them carrying a $1,000 bond on both. You already have both your hearing dates set with both of your judges. Monday for your felony case, and then on the 15th for your misdemeanor cases. So hopefully next week you can wrap this whole thing up and be on your way, okay?
Yes, ma'am.
All right, good luck to you.
Yes, ma'am. Have a good day.
Next we have Ryan McNamee. Bonded, okay. Finding a probable cause on the affidavit. Then we have Wilder. There he is. Thank you. All right. Do we have a probable cause argument?
Yes, Your Honor, I think we had this discussion earlier this week. This firearm is not concealed. The officer writes in his report that when he looked inside the car, he saw the black semi-automatic handgun lying on the floor of the right rear passenger floorboard that was right next to Wilder's feet. That is not a concealed firearm.
And
Your Honor, I'm still relying, I believe it was Smith v. Florida, the same case I presented to the court yesterday.
and I made a specific finding yesterday citing the Supreme Court case indicating that that it's a factual issue for the jury is to make a determination as to whether it was concealed, partially concealed, or and there were several cases that laid out what the requirements would be for carrying concealed firearms. So if anyone needs to pull the record, it was from, I believe it was yesterday, yes?
Sounds to me like an issue that might never get to a jury once a motion for directed verdict is argued.
Maybe you're correct, but irrespective of that, at this juncture, we're at a probable cause determination, and I respectfully decline to find in your favor, and I'm going to go ahead and find that there is probable cause for these arrests. Sir, you've got a carrying concealed firearm, resisting an officer without violence, operating without a valid driver's license, and operating a vehicle in unsafe or improper equipment. The main charge here is the concealing the firearm matter, which has a $1,000 bond. Mr. Romero, can your client post that bond?
He believes his girlfriend will be able to post the bond, but I believe this is his first arrest. Judge, for mitigation purposes, if that's true, and Mr. Lunder can confirm that, would Your Honor consider an ROR? For mitigation purposes, you could take into account my colleague's argument as far as the strength of the state's case. It doesn't sound like it's is as strong as other cases that we have appearing before you.
Actually,
I'd ask you to-
yesterday's argument was better than today. At least the probable cause affidavit yesterday had a reference that the police officer said it was in plain view. This one makes it appear from a review of the probable cause affidavit that it was partially hidden and or not actually observable until there was a looking for it. So I disagree with that, and we're still in a position where I have a firearm that we're talking about, so I'm not inclined to release him on his own recognizance. You are correct that he doesn't have a background other than a driving while license suspended.
In that case, he informed me that he believes his girlfriend, like I said, will be able to post his bond.
All right, well, good luck to you, sir. Pierre Lewis?
His sister is here, Your Honor.
Okay. Ma'am, you're welcome to take us, to have a stand at the podium if you wish. You don't have to. It's just a matter of whether you're going to say anything for me or not. If you want to say something, I'll need for you to be at the podium so I can swear you. Okay? All right, so, sir, your sister's present to support you here. We have a situation where I have 4 counts here. A couple of them are traffic infractions, driving while license suspended, third or subsequent offense, affixing a license plate not assigned, tag unsecure, failure to display vehicle registration. I have a $750 bond on count 1. I do find probable cause. Ma'am, did you want to be heard, or are you just here for support? Just for support? Okay, very good.
Your Honor, she did indicate to me that she believes they could post a $200 bond for Mr. Pierre Louis.
Okay. Does he have any failures to appear in his record?
Your Honor, I don't know if he had, I don't see anything local, but then again, I see his listed addresses in Jacksonville. I don't know if he has any history outside of Broward.
You all live here, or?
My brother recently moved back here. He was in Jacksonville and having a hard time.
Is he staying with you or or staying someplace else?
Unfortunately, he's kind of just been living in his car. He had some issues with the family, and we just really didn't get along. He's been trying to better himself. That's one of the reasons why he's back down here. But
Okay. Can we utilize your address at least for purposes of sending his next hearing date? Because
Sure.
if we need an address to let him know, even if I reduce the bond, he's still gonna have to come back to court on this matter. So, sir, I understand from what your sister is telling me that you may have fallen on some hard times here, but you can't be in a car, and you can't be in a car that doesn't have all of its proper documentation. You don't have a driver's license, so you can't be driving. So I have to have an assurance from you if I consider reducing this bond that you're not going to be driving. Do I have that assurance from you, sir?
Yes, ma'am.
Okay. Are you going to try and help with the bond?
yes, ma'am.
And you believe you can manage it to $200?
Yes, ma'am.
Okay. Your sister's gonna put up this money for you. She'll lose that money if you don't show up to court. Do you understand that?
Yes, ma'am.
Okay. What's your address, ma'am? 1133 Northwest
5th Street,
5th Street,
apartment 1,
number 1.
Fort Lauderdale, Florida 33311.
Okay, we'll make sure that this gets updated. Sometimes it doesn't, so it's really easy to find your next hearing date. All you gotta do is look online, look on the clerk's website. They post the next hearing date on it. We'll try and send you a notice of his next hearing date. When you post the bond, they'll take your information down as well, so that they'll send you notice of when his next hearing date is, and I'll go ahead and reduce it to the $200 for you. Sir, you're very lucky your sister's willing to do this for you. Don't let her down, okay? Okay, thank
Yes,
you.
ma'am.
All right, thank you, ma'am, for your patience. Good luck to you. Jesse Mosley,
North Broward.
Mr. Mosley at the podium for North Broward, please. Thank you. Good morning, good afternoon, Mr. Mosley.
Good morning, Judge.
So I don't know, I think this is a, mainly a paperwork issue, I'm not positive. It looks like the state attorney's office has changed, or someone has changed the charge. Mr. Linder, can you explain to me what's happening?
Your Honor, this is actually an upfile. When Mr. Mosley was first arrested, he was charged with robbery with a weapon. Judge Benson found probable cause and set a $50,000 bond. It was, and I provided you also a copy of the original PC affidavit. It just mentions a knife without going into any really great detail. The state upfiled it to robbery with a deadly weapon, which is a punishable by life offense. And there's more detail. And I apologize if when the court is done reviewing, if I could provide a copy of the packet to Mr. Reedy. I was in a rush and I forgot to print out 2 copies when I
Do
printed
you
them.
have a copy to give him? I've already had an opportunity to look at mine, so I can give him mine.
Yeah, that's what.
Okay, yes. So, Mr. Reedy, you want me to recall this so you have a chance to look at this? Okay. All right. So, sir, your attorney needs a moment to look at some of the new paperwork that we have here, and they appear to be upcharging your file, which could potentially impact your ability to post a bond. So if you'll just wait for us for a few
Judge, you can
moments.
go ahead with Mr. L'Esperance if you want. He's also in North Broward.
Oh, he's there?
I don't know if he's there or not, but
Okay.
that's where he's supposed to be.
All right, other than Mr. Mosley, is Mr. L'Esperance there at North Broward?
No, Your Honor, that's not him.
Okay, we'll try one more
She
time
got
for
the
tomorrow.
She didn't
I
send it
will
to you.
deal
She
with
just
him
sent
one
it to
way or
me.
another by tomorrow. We'll put him on the afternoon docket, please.
She said yeah. But you said
All right,
something
very
else.
good. So what's the state's, I'm ready for Mr. Mosley again, if you could have him come back to the podium. Sorry about that. Okay. So, Mr. Lender, go
Your Honor,
ahead.
based on the additional information, the state would be seeking a no bond hold now on the punishable by life offense. I believe for today's first appearance purposes that there is proof evident or presumption great. Also noting, at the time of his arrest, I believe Mr. Mosley had 2 pending felony cases. Judge Benson revoked his bond on each of those cases. He's currently being held no bond on those.
I would agree that there is probable cause, so I do not have a probable cause argument. And in light of the fact that Mr. Mosley is being held no bond on count 2 and count 3, I would reserve any argument reference proof evident presumption great until he appears in front of his division judge.
All right, very good then. At this time, I'm going to make a preliminary finding of proof evident presumption great with the understanding that I'm permitting the defense attorney to present whatever argument they wish to present to the assigned judge, and for the assigned judge to make their own independent determination on the finding. So, sir, unfortunately, this is just it was just an exercise in an administrative matter. You're already being held no bond, so you're really not going anywhere. And now you're being held no bond on this one as well, okay? All right, good luck to you, sir.
Thank you.
Bye-bye.
Or whoever.
All right, going back to Mr. Edwards, back at the main jail. Mr.
I need someone to
Romero, have you had a
get
chance
this
to speak
now
to him?
DTU.
I sure did right now, Judge.
All right, terrific. So I have to make a review for a probable cause determination. I have had an opportunity to review it. Is there any argument regarding probable cause?
No, Your Honor. The probable cause affidavit seems to indicate he was kicking the officers with his legs, which I guess would
Result in
qualify for resisting arrest with violence, but it's not a very strong resisting arrest with violence allegation.
Thank you. And what's the state's recommendation regarding Mr. Edwards on a bond amount? And does he have other cases pending?
Yes, Your Honor. Mr. Edwards is currently out on ROR for obstructing, tampering with fire equipment, and grand theft. Additional priors: 2001 grand theft auto, resisting without violence, 10 years in state prison as a habitual offender. 02 arson of a structure, 15 years and a day state prison as a habitual offender, PRR offender. He also has previous convictions for aggravated assault, burglary of a dwelling, and robbery with a firearm or deadly weapon. As far as resisting with violence, the state would be requesting a $5,000 bond. And with regards to the open charges, that's in the court's purview.
Okay, and the case number on the open charge?
That would be 17-11608 CF10A.
Mr. Romero, anything on behalf of your client on a bond amount for this case?
Yes, Judge, and speaking with him, from what he advised me, he's been living here his whole entire life. He's 41 years old, was brought up in this community. Right now, he's living in Fort Lauderdale with his girlfriend. He's the sole supporter of him and his girlfriend. He's currently employed. He works for a company called Warren's Construction. He's been there for about 2 months now, making approximately $14.75 an hour. However, he has right now no sort of disposable income, which his girlfriend can obtain to try and post his monetary bond. So right now, he has no resources to post bond. He does have other members in the community, his family, his mom, who live in Broward County. So he does have strong ties to the community. Judge, we'd be asking you to consider releasing him, not just on stand trial, but releasing him potentially on level 2 pretrial. Therefore, he would be allowed to go to work, and at the same time, he'll be supervised constantly. Judge, we'd also ask you to enter an order allowing us to photograph his injuries that he sustained, Judge.
I have no problem with the photographing of the injuries. I'm reviewing his open case before Judge Dennis Bailey at this time. It appears that just recently Judge Bailey had released him on his own recognizance. That would have been on November 13th, 2017, and now we have a new arrest here. He does happen to have a hearing already with Judge Bailey on December 12th, which is Tuesday. His arraignment hearing is scheduled on that day. I'm going to go ahead and revoke his bond in case number 17-11608 CF10A and accept the state's recommendation of a $5,000 bond on count 1, $100 on count 2, $1,000 on count 3, $100 on count 4. And that'll take care of Mr. Edwards. Yes, sir.
In reference to his open case, would you consider not revoking his release on that case? You said he has a court date already scheduled in front of Judge Daly. Certainly on that day, the prosecutor could file a motion to have his bond revoked. The judge assigned to that case could see if that is warranted. I'd ask you at this time to defer on that and not take any action.
I respectfully decline to do that. However, if you'd like, I'll make a little note on my order from today indicating to Judge Bailey that if he wants to address the bond, he's welcome to do so. But I feel concerned that if for some reason over the weekend that his family were to be able to post the bond that was just been implemented, that we'll have a problem. So I'm going to go ahead and revoke it. I'll put a note on the order for Judge Bailey. Thank you. That just takes care of the first appearance docket. Now I believe what we have remaining are the second looks and the release on their own recognizances, if that's correct. I have, let's see, I have 3 documents here in front of me, so.
Your Honor, copy had 2 inmates, if you like.
Okay. Okay. So I'm sorry, which jail were you asking me to start with? Conti? Okay. And who are the two folks in Conti?
So your name?
Terry Cyrus, Your Honor.
Okay, let's find Terry Cyrus. He is on the first page of the second look docket. Yes, he is. There he is. Possession of cannabis. Is this correct that he's been in custody 36 days?
I'm sorry, Judge, who is this?
This is Mr. Cyrus on the second look docket, page 1, excuse me, page 2.
County sentenced till December 11th on 2 violation of probation cases. So the misdemeanor is
Okay, so he's scheduled to be released on Tuesday, completing his sentence, is that what you told me?
Yes.
Okay,
Yeah, Your Honor,
yes, sir.
frankly, and because he's county sentenced on the VOP, there is no more probation. Obviously, I have no objection to an ROR. If Mr. Cyrus would like, the state's offer would be a withhold court costs on the cannabis, and I'd offer time served on the trespass. It wouldn't hurt his probation since there is none anymore.
Okay, so, Mr. Cyrus, I don't know if you heard the prosecutor, but he's willing for me to resolve this matter today, which would basically, the way we would resolve it is withhold on the cannabis charge, time serve on the trespass charge. You'll be able to be released the same time that you finish your county sentence. Are you interested in taking care of that?
Yes, ma'am.
All right, terrific. If you'll please raise your right hand. Do you solemnly swear firm testimony you're about to give today is the truth?
Yes, ma'am.
All right, you can lower your hand. You understand that you have a right to have an attorney, you have a right to go forward with a trial, you have a right to have the state bring witnesses to prove the allegations that you were in possession of cannabis and that you were trespassing. You're giving up all those rights today in order for you to plead no contest and have the sentence that we just discussed. Do you understand all your rights?
Yes, ma'am.
And you're giving all those rights up here today?
Yes, ma'am.
Is anyone forcing you or threatening you in any way to give up your right to a trial?
No, ma'am.
Are you pleading no contest?
Yes, ma'am.
All right, I'm going to go ahead and accept your no contest plea as freely and voluntarily given. I'm going to go ahead and withhold adjudication as it relates to the cannabis charge, so that will not affect any attempts that you have to keep a valid driver's license. And I will go ahead and adjudicate you guilty on the trespass charge, sentence you to time served. On the withhold, I will take judicial notice of the time served and impose any court costs that are associated with either of these charges. Additionally, you'll have a year to pay off any court costs associated with this, okay?
Yes, ma'am.
Any questions for me?
No, ma'am.
All right, sir, good luck to you. Stay out of trouble.
Thank you.
All right, who else do we have at Conti?
Valentine, on the second look.
Okay, I found it. Hello, Mr. Valentine. I have
Thank you, Your Honor.
hello, I have a circumstance here where you have a possession of cannabis charge. If, and,
He was also being held on a VOP. His probation was reinstated.
his probation was reinstated?
Yes, and frankly, considering that it was reinstated and I would imagine he's being supervised, I have no problem with an ROR.
You want to ROR him?
I don't have a problem since he's going to
Okay.
be under probation supervision.
Okay, so sir, they're willing to release you on your own recognizance on this matter, so you'll be put back on probation, and you'll have to deal with this case going forward if they charge you, okay? I mean, if they file charges against you, okay?
Okay.
All right, make sure you report to probation, and make sure that you check with your probation officer for the upcoming hearing dates regarding this cannabis charge, because you don't want to end up getting violated for missing a court hearing, all right?
Got it. Thank you.
All right, take care of yourself, sir.
Paul Ryan indicates they have Harriet Singleton, page 2 of the 30-day motion docket.
If I could just take a, yes, sir, you have someone else?
On the 30-day docket, James Dieter, he's still out the court.
Well,
He's in courtroom 10170 today, this afternoon.
He's page 3, James Deiter. So he's not physically there right now because he's in a court hearing.
Correct,
And
correct.
he's on a ROR.
We received something for him today. I'm not sure for which case,
Okay?
so,
Did the state file?
Your Honor, the state did file an information. What I would ask is if the court can make a finding denying the motion today. I have no problem if the defense wants him brought back tomorrow just to be advised of this, just since the hearing was set for today and it's a timing matter.
Okay, all right, so I'm gonna go ahead at this time, find that the state has filed within the timeframes prescribed. I'll deny the motion for release on his own recognizance. I will, however, set him over for tomorrow so that we can inform him of the fact. Okay? All right, so that takes care of that. I'm gonna go on a really, really quick 5-second break, if you all will just give me a moment. back on the record. All right, what happened to my TV camera?
Oh,
I think they're
that's all-
done there,
yeah.
Judge. There,
The
I
main
think you need to
jail's
go
done.
to Rhine and North Broward, I think are the only jails we have left.
Okay, North Broward still have some folks?
Yes, Your Honor.
Okay, and Paul Ryan does, Conti's finished?
I believe so, Judge.
Okay, all right. Yes,
There's one
Mr.
case
Linder.
on the first appearance docket. I wasn't sure if we called it was a reset. Scott Lesperance.
Yeah,
He's on
he's still not
medical-
available.
He's still on medical
Well,
reset
and Your Honor did say yesterday you were going to address the matter if it was a reset again.
by the end of the week.
Oh, okay, okay.
So I
My-
still have one more day.
Yeah,
You're
no,
stuck
my
with me
mistake.
for one more
All right.
day.
Well, I don't, but I won't be here.
You won't be here tomorrow?
No.
What? I'm gonna court order you to be here. All right. So we'll take care of Mr. Lesperanza tomorrow. All right, so since I have North Broward on the screen right now, let's take care of who's remaining there. Deputy, who do I have left at North Broward?
Is Mr. Roberts Patrick?
Robert.
Yeah.
Roberts. Here he is. He's on page 2 of the motion for ROR. Hello, Mr. Roberts. How are you?
I'm all right, ma'am.
Okay, Mr. Roberts, you're here for a motion for release on your own recognizance to determine whether the state attorneys filed their charges against you, Mr. Linder?
Your Honor, the state has not yet filed an information on this case. He is entitled to an ROR on this charge. I do see he's being held on multiple felony probation violations.
I did discuss Mr. Roberts' case with his Assistant Public Defender, Anne Marie Sapp. And basically, it's up to Mr. Roberts. I think she's explained to Mr. Roberts that he would not get time served on this if the court was to grant the ROR, and he would not be released because of the other holds. My understanding is that it's Mr. Roberts' desire to have the court grant the motion for ROR anyway. Is that right, Mr. Roberts?
Yes.
Okay. All right, so Mr. Roberts, you've had an opportunity to speak with your attorneys. Your attorney is suggesting that you not have me grant this only because there's a chance that in the event the state attorney's office does file against you, that you won't be receiving credit for time served on this matter. But it's your ultimate decision. You're not going anywhere because of the violations, but I'm happy to grant this if you want me to.
Scan it and email it to me.
Yes, but it's the only thing holding me is on my violation. So when I go to court on my violation, the judge,
That's
Judge
fine.
Bob already said that this was holding me, so he set them off 33 days to find out if the state gonna file charges or not. So that's
Sound-
the only thing holding me.
Perfect. All right, then, if you've already had that conversation with your assigned judge, I'm gonna go ahead and grant your motion based on the fact that the state attorneys failed to file an information. Good luck to you, sir. Who else do we have at North Broward?
Ms. Donuts, Anna?
Anna
Good
Dones.
afternoon.
Anna Jones. Hello, ma'am. How are you?
Good afternoon, ma'am.
You have, it appears you're on my docket twice, on page 2 and 3. Does she have 2 cases pending?
Your Honor, when she was arrested, she had a municipal ordinance charge and a state charge, so they split them up, and since they can't be under the same case number.
Okay. And so she's on the second look?
Yes.
All right, so the municipal ordinance one is, what's the charge on that? Oh, I see it. So
It's,
there's
yeah,
loitering and paroling.
And resisting without violence on count 1. When she was arrested, Your Honor, it's actually 3 counts of resisting without violence. When she was brought in, she had a violation of probation on a felony. I'm showing that her probation was terminated. So these would be the only charges holding her. The state's offer on the resisting without violence would be an adjudication time served. Obviously, I can't make an offer on the municipal ordinance.
All right, ma'am, the state attorney's office is fine with me trying to resolve these matters for you today. If you're interested in doing that, I do need to make sure that you understand that you have a right to have an attorney represent you for the municipal ordinance case, and that you do have a right to go forward on your trial on both of these matters. Are you interested in resolving these matters for time served?
Yes, ma'am.
All right, please raise your right hand to be sworn. Do you solemnly swear a firm testimony you're about to give is the truth?
Yes, ma'am.
All right, you can put your hand down. Again, I need to just make sure that you understand that you have a right to have an attorney, you have a right to a trial in this matter, you have a right to have the state bring witnesses to try to prove the allegations that they've made against you. You understand that you're giving up all these rights?
Yes, ma'am.
Is anyone forcing you or threatening you in any way to make you plead no contest here today?
No, ma'am. No,
All right,
ma'am.
then. And are you pleading no contest?
Yes, ma'am.
All right, very good. I'm going to go ahead and accept your no contest plea as freely and voluntarily entered. I'm going to go ahead at this time and adjudicate you on both of these matters, sentence you to time served, and give you a year to pay any court costs associated with these matters. So now that your probation situation has been resolved, this will be resolved as well, and you'll go ahead and be processed to be released. Good luck to you, ma'am.
Thank you very much,
You're
ma'am.
welcome. Anyone else left at North Broward?
Last one, Ms. Smith, Amanda.
Amanda Smith, thank you so much. Ms. Smith, she is on page 3 of our docket.
Yes,
All right, what's the circumstances with Ms. Smith?
This
Hello,
was
Ms. Smith.
this was actually downfiled from a felony theft, Your Honor, to failure to,
Looks like defrauding an innkeeper.
defrauding an innkeeper, Your Honor. I reviewed the probable cause affidavit. Frankly, at this point, because she has 24 days in, I have no objection to the court RORing her. I would ask that the court not entertain resolving at this time, only because there is a restitution matter. While it's not a significant amount, IHOP, a representative from IHOP still has a right to be heard as to the matter.
Okay. What about, is it your position you'd like to go ahead and have her resolve?
Want to release her on her own recognizance, Judge. I'm sure neither Ms. Smith nor I would object.
All right, well, the only concern I have, ma'am, I don't know if you have a regular residence and you have an address that we can send you any hearing notices in the mail. Are you interested, or do you have someplace that we have a permanent address for you that we can send you a notice of hearing?
And Broward Outreach?
Broward Outreach? I understand that the state may think that the IHOP folks may want some restitution in this matter, but if you like, over their objection, I'd be interested in resolving this matter for you today, if you'd like for me to just go ahead and take care of it and put it behind you.
Yes, ma'am.
All right, very good. Will you please raise your right hand? Do you solemnly swear a firm testimony you're about to give today is the truth?
Yes.
All right, very good. You can put your hand down. You understand that you have a right to have a trial in this matter, to have the state bring the witnesses to prove the allegations against you, and to have an attorney represent you during the trial process. By pleading no contest here today, you would be giving up your rights to all of these, your right to the trial and to everything. Well, I'm sorry, it's been a long day. You're giving up your right to your to a trial in this matter. Do you understand that?
Yes, ma'am.
Is anyone forcing you or threatening you in any way to plead no contest here today?
No.
And are you in fact pleading no contest?
Yes.
All right, I'm going to go ahead and accept your plea of no contest here today as freely and voluntarily entered. I'm going to go ahead and adjudicate you on the down charge file, adjudicate you, sentence you to time served, and give you a year to pay any court costs. And that'll take care of it, ma'am. Good luck to you. All right, is that everyone at North Broward?
Yes, ma'am.
All right, thank you. Have a good evening. We'll see you tomorrow. And then all we have left is Paul Ryan. Okay. And who is this lovely lady at Paul Ryan? Ma'am, your name, please?
Harriet Singleton.
Ms. Singleton, good afternoon. I'm here to determine whether you can be released on your own recognizance. The state attorney's office would need to have filed possession of cocaine charges and possession of cannabis charges against you. Mr. Linder, have those charges been filed?
No, Your Honor.
All right, so ma'am, apparently the state attorney's office has not filed these charges yet. It may have something to do with the fact that they haven't tested the drugs yet. I'm going to go ahead and grant your motion to release you on your own recognizance today, with the understanding that there's a potential that you may have a hearing on this matter in the future.
Yes, ma'am.
You need to make sure you keep an eye on it, and if you get any hearing notices regarding, make sure that you go to your hearing so that you don't get rearrested. Do you understand all of that?
Yes, ma'am.
All right, very good. I'm granting the motion to release you, and they'll be processing you to be released today. Good luck to you.
Thank you.
All right, take care. All right.
Thank you.
Anyone else? Is that everything?
We do Michael Bonfort
No, we
and
didn't.
Jenna Palmer.
Where's Mr. Michael Bonfort? And Jenna Palmer. I'm still missing 2 people. They're all gone.
They're what?
All the jails are closed up. Nobody's left. How did we miss?
Well, Mr. Bonfort bonded out.
Okay.
Okay.
He bonded out in November, from what I can see.
Okay, I'm gonna go off the record now and finish these last 2.